This year's Criminal Law Conference brings together some of the best and brightest minds of the legal profession, an all-star cast, if you will, including magistrates, judges, QCs, renowned academics, as well as our esteemed colleagues and peers. Our keynote speaker for today, Nicholas Pappas, QC, Acting Director for Public Prosecutions for the Northern Territory. His topic today is on the extremely relevant and contemporary topic of trial by media and the criminal justice process. I look forward to introduce you to Nick Pappas. Thank you so much.
So today's topic, and one that I'm hoping to raise some issues for and to give you some information and just share some experiences, is all about, when I say all about the interplay between the media, our justice system, and the sorts of things that affect our clients' rights and the efficacious and proper process that we require of the justice system. We don't like the idea that the justice system doesn't work at times. We don't like the idea that things go wrong. We certainly don't like bad publicity, do we? And sometimes we read headlines in various newspapers suggesting that there's been some outrage or another, some sentence that was not acceptable. And often enough, things do go wrong. We know that, we don't like it, but we're doing our best. But when I was first Chief Magistrate, and that's an eon ago, and there's been a few since me, and it's amazing how people still call me former Chief Magistrate. I left in 1996. I was a young person. I was only in my 30s when I was made Chief Magistrate, and I was still in my 30s when I left being Chief Magistrate. But when I first started, when I was first made Chief Magistrate, I had a little knowledge, which we all know is a very dangerous thing, about what the media does, I thought. But I soon discovered, and I'm sure you've discovered, that what lawyers think is good copy and important information in the media, and what media thinks is important information, often diverge wildly, don't they? I remember sitting in Court 1 at the old Magistrates Court in Russell Street. I don't have an age profile, I'm probably not allowed an age profile as to who's listening to this, but I suspect many of you never went to the Russell Street Magistrates Court in Court 1. When I was made a magistrate, I was sitting in Court 1, and I had fond memories still then of watching Darcy Durgan, who was a Chief Magistrate of great repute, doing his shtick. Now, I'm sorry if I'm being too flippant about that, but he had a very nice banter about him. He was fantastic. And I remember learning my trade in that courtroom, Court 1, how we'd all be crowded around trying to see our clients, milling around with the police in the back of the court, walking back through the courtroom and trying to take your seat and get on and get your case on. Now, back then when I was a magistrate in Court 1, by then we're in our new court, I think, I remember sitting there and coming on the bench at 10 o'clock. Now, I'm not sure if much has changed these days. No one really seems to be ready to start at 10 o'clock. There's all sorts of reasons. I would come in and I'd sit there and people would look at me and say, what's he doing here? Really quite a surprise when you think about it, because I thought I was the magistrate. But anyway, no one was ready. They were all sort of trying to get organised, doing the deals and so forth. They were baffled at the thought that I'd actually want to hear a case. But they soon learned that I was only there for a relatively short time, and I had other things to do, administrative matters, and perhaps the next magistrate coming in wasn't quite as readily disposed to, or kindly disposed to the plea material. I think my reputation was one of being reasonably soft, I think. Those who disagree with that can make a comment in the chat room, but I reckon I was a soft touch. And when they realised that, you know, Judge X, or Magistrate X as they then were in those days, was coming in, they got a shock, and everybody tried to get their cases on very quickly. And so we did start getting a few cases, especially when the next magistrate was going to be someone not quite as readily disposed as my good self. Now, the divergence between what I thought I knew about the media and what I discovered about the media developed fairly quickly. And by that, I mean that I got to understand it. I still to this day remember a case that involved two young guys from South Australia who had come over to Melbourne and had decided that they were going to do a bit of graffiti, and they went crazy. They went all over Flinders Street, and they went all over the trains, and it was a really quite outrageous stunt. It was pretty much a cross-border raid. And there was a lot of publicity about it, and people were outraged, and trains had been defaced, and it was just horrible. They'd been remanded in custody, and they'd spent 2 days at Pentridge. And again, some of you may have been out to Pentridge and seen what that was like. I don't think anything's much better, to be quite frank. But anyway, they had been out at Pentridge. They hadn't liked it. Their duty lawyer was in court making the submission along the lines of how they'd learnt their lesson, how sorry they were, how imprisonment had been a salutary lesson. They needed to go home. They were isolated. They're very, very sorry, and so forth. And I'm not being flippant, but you can understand the sorts of submissions you'd make. Now, can I make a confession? I'm sure it didn't influence my decision at all, but I was pretty grumpy at that point. It was entirely unrelated to the decision. I'm immediately emphasising this. But only some months earlier, my pristine fence had been graffitied by someone unknown, and it had led me to having to, getting rid of the appalling tags or whatever it was that they put on my front fence. And perhaps I'd formed a bit of a set against graffitiing. Now, having put that aside, having been entirely impartial and having heard the careful submissions of counsel, I took the view that these characters needed just a bit more jail, then they could go home to South Australia. And I don't recall whether it was 7 days or 14 days, but it was a sentence that led to further imprisonment. Now, the reaction from the media that day, that night, on the TV news, the next morning in the newspapers, was extraordinary. It was unbelievable. The unbelievable praise that I received for having been seen to be tough. There was great judicial activity going on, that I was pretty much the best thing since sliced bread. What a fantastic thing it was that these people, these outrageous graffitists went to jail, etc., etc., etc. If I'd been minded at that stage to stand for some position, the Pope, perhaps Premier, Prime Minister, I reckon I would have got in. Now, I was apparently what all good judges need to be: tough, uncompromising, harsh on sentence. And I knew that the impact of sentencing was important, blah, blah, blah. All right. Now, I've got to say, I had no idea. I just thought I was responding to submissions. I thought it was an appropriate sentence in the circumstances. I was managing a busy list, and I just had two silly young men who, having done something really stupid, and I gave a relatively sensible sentence, I thought, because the damage was in the tens of thousands of dollars, and it could have easily been a longer sentence. So there was my first experience at the power of the media in complete isolation and contrast to what I thought I'd done. I just thought I was doing a little case. All of a sudden, that was it. Fantastic. Now, since then, I've had a lot to do with the media. Incredible career in one sense, from my own humble point of view. I've really enjoyed myself. I've been lucky. Many of my colleagues say, though, that I have far too much to say. Some of you might agree with that, and I apologise. A good friend, now a retired judge, senior judge, would ask me every day when he saw me over lunch or over a cup of coffee with a critical voice, "Been in the media again, Nicky? Just stop it." He's of the view, uncompromisingly of the view, that you don't talk, that lawyers have no place whatsoever in talking to the media. Now, you can understand that because it's a difficult exercise. Many lawyers are quite properly very nervous about having anything to do with the media, and how it's like, a bit like grabbing a tiger by the tail. There are a number of stories I'd love to tell, which I really can't tell, about how media reacted to particular things. But the fact of the matter is that if you think you understand the media, and if you think you know how the media will react to particular things, then think again. It's bigger, it's more diverse, it's completely independent in the sense that the individuals and the editors and the organisations are doing things that we, as humble lawyers, generally have no idea about. We can guess, we can adjust, we can deal with, but the fact is that we have limited capacity to do anything about how the media ultimately deal with particular issues. Now, one of my problems is, and the reason why I tend to speak a lot to the press, is in the absence of timely and reasoned discussion and explanation of general principle and practice, the space in the public debate is taken up by commentators or others who have no reasoned or balanced view. The criminal justice system, as we all know, is a blunt instrument that often does not provide any comfort or satisfaction to victims, to accused, to police, and of course, the representatives, the fourth estate, and media. The community is often left with a sense of deep disappointment, often a disproportionate sense of crisis and trouble. Now, I've gone out of my way, and sometimes subject to a fair bit of criticism, to try and respond to requests for comment or analysis in the media. Both print media, TV, news, current affairs, still, not now where I'm in my acting role as DPP up here in Darwin, but in the Northern Territory, but as a private barrister would often seek and will still try and seek my views on sentences, sentencing, what the law is in relation to particular types of offending, what it should be, how it could change, and so forth. Now, of course, and I'm going to go to what our rules say, both the Bar and the Law Institute rules in a moment, but I don't comment on my own cases. Never do, never have, never will. And I don't comment on cases that are yet to be decided. Clearly, that's not correct, is it? We would all know that. But sometimes by engaging with a journalist and explaining what the elements of an offence are, or what the maximum sentence is, or why a sentence is lower because the accused pleaded guilty, and why it is that sentences are reduced because accused plead guilty, and what the consequences of remorse are, or why the period in custody on remand is actually real time. Gee, you guess half the time you read stories, and they're going to be released in 2 months because they've spent 5 years on remand and they're only going to serve 2 months. I mean, obviously that's a bit extreme, but how often do you see suggestions that the person is only going to be doing another 3 months as if they haven't done any real jail time in the meantime? So, you know, there's good reason, in my view, to engage. Timely and relevant information and commentary on proposed legislative change can make a difference. Lawmakers are concerned. Maybe I'm being naive here, but lawmakers are concerned to get it right and to avoid bad policy. But the lawyer and the lawyers need to be brave enough to speak plainly and risk being criticised, to speak clearly, to speak without jargon. Don't engage with the media, if you ever were to engage with the media, by way of a legal submission. It's just not going to work. I'm not saying we all have to go and do media training and learn how to do grabs and all the other stuff that politicians and others learn. But I think that the practice is, certainly our organisations that represent us will often give some media training to the presidents, the chairs, the heads of the various areas. And they do that for a reason, because there's no natural ability in the lawyer to deal generally with public comment. Our area, as you well understand, is all about those things that you can see behind me: reading the Australian criminal reports, going through legislation, drafting submissions, being in a position to articulate a balanced, sensible, concise argument that's going to assist the court to get the result that's proper. Media doesn't have time for you to articulate the preliminary argument, the basis for the legislation, the history of it, so on and so forth. You need to get to the point. Now, as a group through the Law Institute, the bar councils around the country, the Law Institute, regional and specialist associations, and as individuals, I think we can make a difference and help preserve the rule of law by being prepared to engage at the right time, in the right manner. As individual practitioners in crime, we understand the importance of freedoms, and we acknowledge that there are few winners in our groups of clients and witnesses and others who are involved in the criminal justice system. But freedoms long understood to be fundamental to the way we live, to our society, are often being attacked, aren't they, by various groups, by interest groups, loose gathering of individuals, organisations that have particular views about things which might not necessarily understand the bigger picture. And as lawyers, I think that we can make a difference. We all agree, don't we, that fair, objective, unbiased, independent and reasoned actions by our judges, by our courts, and by the lawyers who appear in those courts, and it's a hot topic, isn't it, about lawyers who don't do their duty. I won't say the name, I won't mention the cases for fear of people jumping out windows or something, because it's such a bad attack on our system, isn't it, what's happened in the past few years about the lawyer who became an informer and informed on her clients. So the freedoms and expectations of justice have been hard won, and they're easily lost, aren't they, without strong and forthright engagement by those in the system, by the independent people who can speak, because inevitably, as you well know, the judiciary can't. So how often are judges criticised for some sentence or another, for some appalling exercise of judicial conduct, when it's completely misunderstood. And the Chief Judge, the Chief Magistrate, and to a lesser degree the Chief Justice, try and send out a statement or make a comment, but it's very difficult for them. And sometimes it takes a bit of time and possibly too slow at times. As we well know, there are current movements throughout society, many of them vitally important, dealing with racism, inappropriate and sexist and harassing behaviour in the workplace, bullying, sexual assault reforms, constant review of how we manage our lives. And we are part of that. And to an extent where there are things that are going to happen which influence people's rights, then I think we should be engaged. Now, where I'm presently working in the Territory, I was fortunate enough to be appointed the Acting Director of Public Prosecutions quite quickly in July. There's a gap between the previous director going on long service, sick leave, and the appointment of the next director. And so I've been asked to fill in as the Acting Director. I've done a bit of work up here. I quite appreciate the Territory and the complex issues up here, but I've recently had a sense, it's been emphasised for me, of the long way we have to go to achieve what we're seeking to achieve for our Indigenous communities around the country, the closing the gap imperative for First Nations people. And recently, the Northern Territory Government launched the Aboriginal Justice Agreement with the aim of reducing the overrepresentation of Aboriginal people in custody. Hope I'm not banging on too much because I know we're talking about media, but how many of you were aware that around about 30% of the population of the Northern Territory are Aboriginal people? Over 30%, but just over. And yet that 30% managed to constitute 80% of the prison population consistently. Imprisonment rates for Aboriginal people in the Northern Territory are over 2,000 per 100,000. Now, those who know anything about sentencing rates would just say, what? For non-Aboriginal people, the rate is 250 per 100,000. Now, in Victoria, for a period of enlightened life back in the 80s and 90s, I think we had rates of around 50 or 60. I think it's up higher now as a result of various sentencing reforms. So what they're doing up here is introducing strategies under this agreement to reintroduce and support community courts, better community-based and culturally relevant justice, The point of why I'm referring to up here is that the local profession are substantially engaged and they regularly make comment about the effectiveness of the law reform. They speak loudly and clearly. And just the other day, the chair of the Criminal Lawyers Association for the Northern Territory actually publicly said, look, this agreement is not enough. There needs to be more done. And, you know, it's for my part, an example of the way the profession can be very much part of what society needs in terms of ensuring a just criminal justice system. Now, media, of course, is not just the newspapers or the telly. Social media has just exploded in its reach and its nature and has exacerbated the potential for disruption to the criminal justice system. Facebook, most of you will be familiar with. I'm proud to say I'm not on Facebook, never have been. Maybe you're asking me how I can possibly survive without it, but there you are. Instagram, Twitter, WhatsApp, all these other platforms. All of them have the potential to exert huge influence in your cases, on witnesses, on jurors, other participants. And of course, those platforms often are more effective than the traditional media in managing organised campaigns, both in relation to high-profile cases or in relation to contentious issues. And that raises the question then, what duty or responsibility does the legal practitioner have on behalf of their client and with their duty to the court, where something like that is happening, some sort of social media thing or something happening in the media, which might affect your client's rights? The solicitor's rules, as you know, are published and are available to you. Rule 28.1. A solicitor must not, and it's under the heading public comment during current proceedings. A solicitor must not publish or take steps towards the publication of any material concerning current proceedings which may prejudice a fair trial or the administration of justice. That seems fairly sensible, doesn't it? Advertising. Now, you know, years ago, you weren't allowed to advertise. It was not something that was seen as appropriate. But nowadays, you may have noticed some firms advertise. A solicitor must ensure that any advertising, marketing or promotion in connection with the practice is not false, misleading, offensive or prohibited by law. Now, that's what I found in the solicitor's rules. There might be some other references there to media, but the bar rules are quite extensive. And if you want to have a look at them, you can get a link from the National Bar, from the Australian Bar Association, from the Victorian Bar. Media comment, Rule 76. A barrister must not publish or take any step towards the publication of any material concerning any proceeding which is known to be inaccurate, discloses any confidential information, or, and this is the important thing I think for all of us, appears to or does express the opinion of the barrister on the merits of a current or potential proceeding or on any issue arising in such a proceeding other than the course of genuine educational or academic discussion on matters of law. And you shouldn't publish anything, Rule 77, about a case you're likely to appear in. But significantly, this is the part I've emphasised, 77A, a barrister may supply answers to unsolicited questions concerning a current proceeding, provided that the answers are limited to information as to the identity of the parties or of any witness already called, the nature of the issues in the case, the nature of the orders made or judgment given, including any reasons given by the court and the client's intentions as to any further steps in the case. It goes on, but I won't go into that too much. The point I'm making is that there may be occasions where it's important to set the record straight, to have the information made available. Is it not all of our experiences who are active in criminal law that the police media is a well-organised, probably well-funded part of the police organisation. Very slick and seen to be a substantial arm of the police force all around the country. You'd accept, wouldn't you? It's not a coincidence, of course, that when TV crews are there to film the arrest of, as it's reported, drug traffickers or motorcycle gang members, and the seizing of exhibits and Ferraris, etc., is filmed. You see handcuffed people, heads bowed. The inference, the overt inference from the police commander is that they've broken a huge ring, a drug ring. We've got our man. We've broken the drug ring. The streets are safer. Now, what should we do about that? What is there that can be done about it? Defence might be tempted, and why shouldn't you? For a currently innocent and unconvicted person, why wouldn't you not shout from whatever rooftop you can find, i.e. the media, that your client, who's presumed innocent, of course, denies the allegations and will defend the matter vigorously? You hear about that all the time, don't you? I can tell you one good reason. It springs to mind. I'm not saying that it's necessarily right or not, but strength of case, evidence, things like that may explain why you want to be very careful, not just parroting your client's current position, and you'd never make a public statement following arrest, except on strict and unambiguous instructions, reminding ourselves always that it's hard to run remorse in the face of public statements through the lawyer about a case is going to be, how the case is going to be vigorously defended and that he's clearly not guilty and so forth. So, yeah, be careful. Let's have a look at the poll. I'm not sure if it's finished or not, but a significant number have never had a problem with the media. A small number have had once, 20%, 33% more than once, and 16% on numerous occasions. Mostly minor, some moderate, and 10% serious. Now, I can tell you about some cases I did where we had to blow juries. We lost juries because of media publicity. It's inevitable that on occasions, especially dealing with more serious criminal matters, that there will be an effect somehow, whether it's subtle or direct. The law is clear, even though I'm not overly convinced that we all are completely wedded to what the law says on the matter, but it's the law. The High Court, Glennon, Dupas, juries have to be trusted that they will follow directions and can put aside prejudicial material. Now, those of you be aware of the Dupas case and the Glennon case earlier in the High Court. Glennon was a priest who apparently had convictions, or did have convictions for pedophilia, and was still operating in the as a priest effectively. And then he was charged with serious offences. Darren Hinch, of former media fame, I think he's still hanging around somewhere, told the world when Glennon was facing another trial that Glennon was a pedophile with a prior conviction. That wasn't enough to prevent a trial. It wasn't sufficient to obtain a stay. Dupas had 2 priors for murder, and stories of his appalling behaviour were not enough to prevent a 3rd trial. It may be that the solution is that judge-alone trials are absolutely necessary, absolute necessity with respect to those sorts of cases. But it's interesting because we can trust jurors. O.J. Simpson could trust his jury, couldn't he? And Tony Mockbell, was it not the case that Tony Mockbell was highly publicised? He ended up escaping halfway through a trial, didn't he? And there was publicity of him and so forth. He then faced a murder trial and was acquitted. Apparently, we can trust jurors. There's no question about that. We can trust jurors. Now, and I see there with our material that Rachel has put up the legal profession uniform conduct rules, and that will help people in relation to the particular rules relating to publication of material. But what is it that's been said by the courts in relation to prejudicial material, the publication of prejudicial material? Many of you will remember the Rainey case, Lloyd Rainey. He was a Western Australian prosecutor, and he was accused of murdering his wife. And there was huge publicity in WA on the matter, massive amount of commentary. A district court judge, when dealing with another matter later, described what happened in this way. In theory, responsible media reporting is balanced, fair, and accurate to all concerned. This judge said, in my view, having regard to media coverage contained in the evidentiary material before the court, it is not an overstatement to suggest that there was a media frenzy fueled by an insatiable public demand at the time for information. So there is an example of a case which really did suffer from a substantial amount of prejudice. Another case that makes reference to the leading case on media publicity and the effect of it is Murphy and the Queen, former High Court judge, 1988, 167 Commons Law Reports at 94. Now, this is quoting the Chief Justice of the time, Mason, and Justice Toohey. It is fundamental that for an accused to have a fair trial, the jury should reach its verdict by reference only to the evidence admitted at trial, and not by reference to facts or alleged facts gathered from the media or some outside source. However, the might of media publicity in sensational cases makes such a pristine approach virtually impossible. Recognising this, the courts have used remedies such as adjournment, change of venue, severance of trial, and directions to the jury to exclude from their minds anything they may have heard outside the courtroom and the machinery of challenge for cause. All right, well, that's effectively quoting Murphy. It's identifying that there's procedures and practices and processes that permits us to manage the so-called media issue. But the reality is that it's extremely unlikely that there'll be a case ever, based on those cases, where the publicity engendered pre-trial will lead to a stay, a permanent stay. So you can't get a stay. It is likely, though, it is much more likely the trial will be disrupted. Maybe a discharge of the jury, maybe an adjournment of the trial for a period of time, awaiting the media reporting to subside in people's minds. I mean, I've had a couple of jury trials discharged because of media reporting during the hearing. one of which, at least, was on issues not about that case, but about the issues that were directly relevant to the case. As an example, a major in-depth analysis was conducted by a TV public affairs program on drug trafficking, and they focused on a particular suburb, and they were talking about particular motorcycle enthusiasts. It's pretty hard to manage a trial when you're doing pretty much the same topic, pretty much the same subject, and a different group of motorcycle enthusiasts. That was a discharge, even though the media had no idea that what it was doing arguably was breaching the sanctity of that trial by the process. So you've got to be alert, you've got to be available to yourself and to your client to ensure that whatever happens, there's no risk in that regard. If there is risk, you've got to manage it. And clearly, you've got to be very careful to avoid yourself making public comment. You mustn't take steps towards published proceedings. And so I've got the solicitor's conduct rules there up for us as well in relation to public comment during current proceedings. So you've got to be super careful. You've got to be very, very focused on ensuring that whatever you're doing for your client, you're not going to, in a sense, blow the jury. You're not going to express your own opinions. Now, that's very difficult. And some people find it very difficult to resist possibility of commenting about their clients' rights and their possibilities. If you do comment, and if you do say something like, he's not guilty, he maintains his innocence, nothing wrong with that. If you go one step further and say, oh, look, he'll be acquitted, I would have thought you'd be clearly in breach of your obligations. So, discharge applications are always a possibility. If there is unreasonable and prejudicial publication occurring, what can you do? Now, remember the Open Courts Act, and an application of the court for a restriction on publication is available. Be aware, of course, that a failed application, the judge rejects your application, might well lead to more publicity. Accused X seeks to hide behind the closed door of a court, but we, the media, came along and stopped it. So you've got to be very careful indeed. You should be very careful not to seek to enact the provisions of the Open Courts Act unless there is something really central, very vital. In the end, I think the message, my message is, the media are not the enemy. Social media is not going away. The real world does not remove things just because we don't like those things, what they do. We need to learn, as we have with online courts, to embrace and accept, to work with, and to seek to ensure that our system is properly understood and valued. And so if there's a takeout, if there's a message, it is, look at, the media is a fact. People are going to be talking about your case on occasions. It may affect your case. Don't ignore it. Don't put your head in the sand. At the same time, be super careful. And hopefully this has been some interest and some stimulation and some part of the process that you're undergoing today, the very important sessions that are coming, and hopefully stimulate some thought.
That was a really interesting, and we gained a lot from your reflections from, spanning many, many years of engagement with the media and in this space. One of the questions that came through when you were speaking was that it seems like there's sort of a fundamentally different and competing priority between what we want as lawyers in this profession in terms of how the public should understand what we're doing and what we're trying to achieve, and the media's priorities, given that we operate on nuance and sophistication of understanding of complex situations. And for the media, it's simple. It's short, sharp, quick, sensationalist grab. And there's that whole issue of virality, because we know, particularly now that we've got non-subscription media, the way in which a journalist knows he's going to get paid is if there are lots of hits and it goes crazy. And it doesn't get crazy if it's, judge considers all the factors of someone's mental health, their background, their trauma, and comes with a very sophisticated view about what's an appropriate disposition under the circumstances. What we usually get is, thug gets off lightly or something like that. So how do we hope to reconcile that going forward, and what's our role to play as in this space?
So it's almost irreconcilable, isn't it? I mean, that's the reality. The fact is that it exists. And so thought towards what's in the client's interests and what's in the particular interest of the circumstances of the case are really the only way we manage it. So obviously what I had to say was in two parts. Firstly, I take the view that it is our obligation to be out there talking about it, right? If we don't talk about it, if we're not in the space, then it gets filled by others. And so from the generic systemic perspective, let's make ourselves short and snappy and capable of being clicked on. Let's do things. And people are doing it. There's no question people are doing it. For your own client's interests, I didn't want to talk about individual cases that we've had in Victoria, because there've been some that many of you will recognise have been very effective at putting the position for a group of clients or a particular client. And so it's all about reviewing our obligations, ensuring that we can't, that we don't cross over the lines that exist. If it's worth considering, and I see the message come up, would there be any assistance in media training to become part of the story and to maintain otherwise what we say are the existing rights? We need to make sure we don't just sit within our existing environment. I mean, your next presenter, Ari Freiberg, has for years been in that space, because everybody criticises Ari because he gets the sentencing wrong and sentences are too high, too low, and so forth. So it's a reality. We need to manage it. We need to either learn how to do it, and we need to know what's going on, and we need to be aware of the consequences, and we need to, I say, fill the space. Now, if that means we have to talk different, be snappier, then let's do it. I see a quick question. The question is whether there is monitoring made of social media for comments being made in cases. Now, that's a really interesting question. That's Greg Thomas, I gather it. A really interesting question, because I don't know that we do. I don't know that we do up here, but I'm pretty sure we don't. We're sort of relying on our counsel and on our solicitors and on our participants, our police and whoever else is in the case, who are the media savvy ones, who are aware of. I mean, imagine me monitoring social media. I've got no idea. I mean, I do look at Twitter occasionally, but it's the Facebook, it's those other platforms that maybe aren't quite as mainstream. I don't know. Do you get stories on the law on TikTok? I can't imagine people would dance to the law. I'm not sure. Do they?
That would be a frightening prospect. Thank you so much for giving of your time and talking to us today and sharing those reflections, including kind of reminding us of our legal obligations critical in this space.
My pleasure.
So much. Really appreciate it.